Public Safety Committee will not come to order until we have a quorum, but we are able to start as a subcommittee right now with Senator Anderson and myself. We have a very full agenda today. 40 bills to hear, 7 are on consent. We just added an additional consent item. So although we don't usually do this, we will need to limit testimony today to 2 witnesses on each side, no more than 2 minutes each. I may make an exception for some of the items we are hearing that are gut and amends and have never been vetted or voted on in the other house, and a few that actually raise serious constitutional issues. But for the most part, we're going to be 2 on each side, and we will be timing. On our consent calendar today, we have just added item 37, AB 2805 by Olson. In addition, we have item 7, AB 1754 by Waldron, item 14, AB 1924 by Lowe, item 21, AB 2083 by Chu, item 22, AB 2177 by Mainshine, item 27, AB 2499 by Mainshine, item 29, AB 2524 by Irwin. As I said, item 37, AB 2805 by Olson, and item 38, AB 2839 by Lowe. By Thurman. Right. Excuse me, Thurman, yes. Okay, so we can begin today as a subcommittee. Assemblywoman Irwin, welcome to the committee. I don't have an agenda for some reason. No, I mean, I have this. I don't have anything else. Oh, no, here it is. Okay. Welcome to the committee, yes.
Thank you very much, Chair and members, and we have discussed this issue at length already. I would like to start by accepting
This is number 16, yes?
AB 1993.
Yes.
Okay. I would like to start by accepting the amendment proposed in the analysis, and I thank the committee for its work on the bill. AB 1993 ensures that efficiencies and miscommunication are avoided during important law enforcement investigations that involve electronic communications. This bill simply requires that a service provider provide their preferred method of contact to the Attorney General to maintain a directory of such contacts, and ensures that the contact is available and responsive to law enforcement requests. We have worked closely with the industry and have removed nearly all opposition, including the Internet Association, with your recent amendments. I respectfully ask for your aye vote. And with me today in support is Don Hoffman from the LADA's office.
Thank you.
Good morning. My name is Don Hoffman. I'm a Deputy District Attorney in LA County, and I'm the counsel to LA County's CERT team. We protect LA County's information assets from cyber criminals and data thieves. This bill addresses 2 problems that we face every day. It's 2 problems that waste both government resources and providers' resources and hinder law enforcement's mission to protect the public. The first problem is that in high-tech cases, which are highly sensitive cases to time, much like kidnapping, investigators often must waste precious time to determine a provider's preferred method for service and process. Second problem is that once served, requests and court orders often disappear as if into an abyss, and compliance with search warrants in particular is often tardy, violating the 5-day statutory requirement. No communication and no transparency means wasted time, wasted resources, and that harms the public safety. We ask for your support.
Thank you very much. Others in support of the bill?
Good morning, Madam Chair and members. Corey Salzillo on behalf of the California State Sheriff's Association in support.
Thank you. Others in support? Speakers in opposition to the bill? Please come forward. We have two chairs. Thank you.
Morning, Chair and Senators. Alex Alanis with the California Bankers Association. Unfortunately, we still have to oppose the measure. Even with the amendments, it still hurts brick and mortar companies, especially from a bank perspective. A lot of our folks handle these requests inside the branch. As law enforcement comes in and asks for information, the bank does review the information and then assign someone to work on the request. Banks do have a delicate balance between the right to financial privacy and providing information to law enforcement. The industry is somewhat unique in that circumstance that we have ubiquitous presence up and down the state. You can go just about anywhere and run into a bank branch. So finding someone as a contact in the branch is not very difficult. Because you have to have continual availability of a contact person, essentially we will have to have one individual personnel available 24/7 the way the bill is written. We could talk about intent, but the bill does read that way. Also, if you look at the definition of service provider, I mean, in the analysis, which is well written, and discussion of this bill, however, what we hear is always about internet service providers. And I think what's getting lost here is the definition of service provider in the civil code, in which this bill references. It's pretty plain. It covers every single company that communicates with its customers through the internet. It's not the platform. It's not the internet service provider. It is the company. So we're talking about over 1 million companies in California that will have to comply with this. The bill also does not deal with just emergency circumstances. This is every single request that's going to come through our offices. If it's a request for emergency purposes, we handle those differently, whether it's a kidnapping or some sort of Amber Alert. You don't need to come in the branch. There are other systems that working with the credit card networks to expedite the process, to figure out if
Thank you.
someone is
Could
doing
you
traffic.
conclude?
Okay. Just so in summary, you're still opposed to the bill. It does hurt a system that actually works today.
Thank you.
Good morning, Madam Chair, members. Jeremy Merzenbaugh, the California Chamber of Commerce. We'd like to thank the committee, the author, her staff. This bill's come a long way. We are still in opposition for the reasons enumerated by Mr. Alanis. There are still some sectors that are unique. So certainly this bill has, again, come a long way and taken a lot of folks out. But there is still a unique subset of businesses, the brick and mortar businesses, that this could deter or create a disincentive for them to continue a process that works. So that's kind of the last remaining issue that we have with the bill. And today we still are opposed on that basis.
Thank you. Others in opposition?
Robert Callahan with the Internet Association. I'd like to thank the Assemblywoman and her staff. And with the proposed amendments taken, we would pull off the bill. So thank you.
Okay. Thank you. Others in opposition? Seeing and hearing none. I'm wondering, Assemblywoman Irwin, if you could comment on the bank's concerns in terms of brick and mortar businesses as opposed to internet businesses.
And the banks will still be able to use their process if they want to have somebody walk in. All we're asking is for small single banks to have some method of communication, which could just be an email account. For the bigger banks, which are the vast majority of banks, they do have a central number. They have central IT, central ability for law enforcement to contact them. For them, it really wouldn't be an issue. And then talking about service providers, it is really the IT providers, the big internet companies, the companies like Google that hold information, or it's banks that have used proprietary software. So we think that this is completely workable and reasonable, and I would just like to have the DA comment on the bankers issue too.
Frankly, I'm a little puzzled as to the banker's response because this is a bill that amends the penal code, and in particular, it amends 1546 Cal ECPA, and has an even more narrow focus than Cal ECPA. It applies only to electronic communications providers that provide services to the general public. And so I'm not sure what the objection is there, as it would not cover the bank's normal business records. It does not affect their own communications with their customers. For those are just their business records. It would cover communication services that they provide that allow their customers to communicate with other customers and so forth.
Thank you. Are there questions or comments from committee members here? Senator Glazer.
Thank you, Madam Chair. I want to thank the author for her thoughtfulness and efforts on this issue. I think we're all frustrated when, just as consumers, we can't reach people that are important to us and doing our business, and let alone having that happen to law enforcement. I think that the intentions here are really good ones. I'm sorry that there's still some differences with brick and mortar. I think that they really can be worked out, and it would be my hope that they could be worked out. I'm willing to support the bill today, but would just ask the author to continue her efforts to try to find a way to maybe just acknowledge that through brick and mortar, there's certain circumstances that the bill would or would not apply to. I mean, I just think that you're really close, and it's my hope that you can find a way to close that difference as the bill moves forward, if it does. Thank you.
Madam Chair, I have a question.
Senator Anderson.
Of the opposition, is there an amendment that would work for you? Have you thought through what would the language have to look like?
We did ask for an exemption because we think there's a unique circumstance with financial institutions, and I mean banks and credit unions and anyone else providing financial services that have a brick and mortar presence in the state. One, you do have a process that works, and also you have to balance the right to financial privacy. And so if there's something that satisfies that, I think that will be helpful for us. But the way we read the bill, it's very plain. You would communicate with your customers, you're in the bill.
And to follow up with the DA, are they one of the problems that you were experiencing? Is that an industry that you had troubles with as well as the internet firms?
Not with respect to the issues addressed here. There are problems with tardy response from financial institutions. However, they face a lot of challenges, particularly, as if a bank is acquired 3 or 4 times, it can take time to more than 5 days to locate records. I will point out, with respect to our interest in financial privacy and consumer privacy, a lot of these cases are data breach cases, and we do have success in recovering consumers' personal information and in the business email compromise cases in recovering bank customers' lost funds. We recovered $80,000 for a customer last week, and we have that success only when we can act very, very quickly and follow the hacker's trail very, very quickly. And in order to do that, we need swift compliance and back and forth communication with the service providers.
Thank you.
Okay. Well, I want to also thank the author and everyone who worked on making this bill better. I will support it today. We'll get a motion when we have a quorum. I would also, like Senator Glazer, urge you to work with the banks. If they're not the major problem, is there something that we could do? On the other hand, if all you want is to be exempted and the information is needed, I don't know if we can be helpful in that. There should be a way to get that information from financial institutions as well. So thank you. It was a good job of trying to reach a good middle.
And we
Thanks.
really, again, appreciate the work of the committee coming up with the compromise that helped take so much of the opposition off. So thank you.
Thank you. Okay, we will entertain a motion when we have a quorum. Next, Steinarth, item number 3. AB 797, motor vehicles.
Yes, ma'am.
Welcome to the committee.
Good morning. AB 797, the Right to Rescue Act, will save lives. For 10 years, it has been illegal in California to leave your pet in a car in harmful hot conditions. Unfortunately, many citizens don't know it is illegal, or even worse, don't realize how quickly it heats up inside of a car. Every year, law enforcement receives hundreds of calls from concerned citizens reporting animals left inside hot cars. Emergency responders and animal control do a great job responding to these situations, but sometimes the response simply takes too long due to other priorities. AB 797 addresses the rare scenario where law enforcement has been called and may be on their way, but an animal is in imminent danger or of serious harm or death. In this situation, we must give citizens confidence that if they take heroic actions to save an animal's life while they wait for law enforcement to arrive, they will not be sued or criminally charged for doing so. In order to receive this immunity, a citizen must follow specific steps laid out in the bill. First, determine the obvious, that the door is locked, that they cannot enter the vehicle without causing damage. Second, there must be a reasonable, good faith belief that the animal is facing imminent death. Third, contact law enforcement to report the situation. Hopefully, law enforcement will advise them that they're on their way immediately. If the rescuer decides to take the step to break a window to save an animal, he or she must not use any more force than necessary and must remain at the scene with the animal until emergency responders arrive. This protocol ensures that vigilante activity will not occur under the guise of saving an animal. Only if these steps are followed and confirmed by law enforcement will a citizen receive legal immunity for their actions to save an animal's life. We hope that citizens will never need to invoke the immunity provided by AB 797, but if they must take action, they can rest assured that they will not face legal repercussions. And I would like to say thank you to Senator Glazer for being a principal co-author on this measure.
Thank you. Others in support? Assembly member.
I also want to thank my colleague for doing a very good presentation, and Senator Glazer for also participating and helping this bill move forward. I'd just like to urge this committee to continue to pass this. Some of our colleagues, including those said, had participated in the Hot Car Challenge several weeks ago, and when you sit in a vehicle, I mean, these cars can move up to about 40 degrees hotter in about 5 or 10 minutes. So we have the ability to sweat. Animals don't have the ability to sweat. We think it's cruel that an animal is left in a car, and we would urge the committee to pass this.
Thank you. Others in support? Please be-
Madam Chair, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. We're pleased to co-sponsor this measure. In Los Angeles, we've been doing PSA campaigns for over 10 years, trying to make people aware of the dangers of leaving their animals unattended in vehicles. Yet every year in Los Angeles County alone, we get notice of hundreds of animals that either suffer or die because they were left alone. This bill will help resolve that problem. The issue that we have is individuals who are present and who would be willing to do something are often afraid because of fear of civil or criminal prosecution. This bill will resolve that. Thank you.
Thank you.
Good morning, Jennifer Fearing on behalf of co-sponsor the Humane Society of the United States, as well as the San Diego Humane Society, the San Francisco SPCA, and Best Friends Animal Society. And I'd like to thank many present members who have been supportive of this bill, including Senator Anderson, who is also a co-author. I was going to describe several recent circumstances in detail, but I'm not going to. I will just note that just last Thursday at the Art and Fair Mall parking lot, officers removed 3 dogs from a car where the interior temperature was registered at 160 degrees. So we would urge the committee's continued support for this bill. Thank you.
Thank you very much. Others in support of the bill?
Gail Stewart on behalf of San Diego District Attorney Bonnie Dumanis in support. Thank you.
Others in support? Speakers in opposition to the bill? Seeing and hearing none. Thank you very much. I think you'll find broad support on the committee. We will accept a motion as soon as we have a quorum.
Thank you very much.
Assemblyman Santiago, should we start with item 4, AB 1276?
Hey, how are you?
Thank you, Madam Chair. Appreciate it very much. I'd like to first accept the committee's amendments and thank the committee for working with our staff to make this a better bill. AB 1276 will authorize victims of human trafficking who are 15 or under the age to testify via closed circuit. By reducing the exposure of these victims to trauma and other dangers, this bill would enhance public and personal safety of minor victims of human trafficking. I respectfully ask for an aye vote. We have a witness who will also be brief.
Thank you.
Good morning. My name is Neil Layton with the Alameda County District Attorney's Office on behalf of District Attorney Nancy O'Malley in support of AB 1276. As a human trafficking prosecutor, I know firsthand the trauma that victims of human trafficking go through, especially when they have to face and confront their traffickers in court and relive the experiences they go through. For those reasons, this can substantially help in our missions and our goals in order to aggressively prosecute traffickers and continue in ending this modern-day slavery. For that reason, on behalf of Nancy O'Malley, I ask for an aye vote in support of this bill.
Thank you. Others in support of the bill?
Morning, Madam Chair. Sean Hoffman with the California District Attorneys Association in support.
Madam Chair, members, Dan Felizardo on behalf of the Crime Victims Action Alliance in support of this bill.
Madam Chair, members, Amanda Wells on behalf of the Judicial Council in support of the bill.
Gail Stewart on behalf of the San Diego County District Attorney in support.
Linda Warner with the California Catholic Conference in support.
Okay, others in support? Are there speakers in opposition to the bill? Please come forward. Yeah.
Morning, Madam Chair, members. Are there any other members here? No. Madam Chair. Micah Doctoroff on behalf of the ACLU of California here in respectful opposition unless amended. We have opposed this bill unless amended to remove the provision expanding the use of closed-circuit television for the testimony of witnesses, which is currently limited to children 13 years of age and younger. We understand the author's goals of protecting young people, and we do not mean to diminish that goal, but these concerns must be balanced against the rights of defendants and the state's interest in accurate fact-finding. The U.S. Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to be confronted with witnesses against him. Historically, California has been very cautious about enacting legislation that could undermine the criminal fact-finding process or inadvertently lead to wrongful convictions. Expanding the use of closed-circuit television to teenage witnesses up to 17 or 15 strays too far from the limited circumstances in which the procedure has previously been approved and threatens to undermine our criminal process. Therefore, we respectfully oppose AB 1276 unless amended to remove this provision. Thank you.
Okay, thank you. Are there, the provision, by the way, is age 15 and under, right? You said 17, but that isn't my reading of the bill. Are there questions or comments from members of the committee? Would you like to close, Assembly Member? I think in this case, 15 and under does make a lot of sense, and I look forward to supporting the bill when we get a motion, when we have a quorum.
Sure.
But if you'd like to close.
Thank you, Madam Chair. I respectfully ask for an aye vote.
Thank you. We don't have a quorum, so stay tuned.
Appreciate that. Thank you.
Thank you. Okay. I think you have another
Yes. And we're waiting for-
bill. Yes, I'm coming down here. Item 30.
Thank you.
Hello.
And thank you very much, Madam Chair and members, and particularly I'd like to thank the chair for spending the last week or so talking to me about this bill and being very generous with their time to try to find really why we're doing this. AB 2533 requires 3 business days notice to be given to a public safety officer before a public agency releases any audio or video of the officer recorded by the officer. Oftentimes when officers are involved in serious incidents, they face threats from criminals or members of the public. The release of audio or video related to the incident may result in threats against her or his family or themselves. AB 2533 ensures that officers provided with 3 business days' notice before the release of any audio or video recorded of the officer, allowing the officer to complete the necessary legal arrangements should they believe there's any bona fide threat to themselves. This measure updates current law. It is more appropriate to today's digital age, while continuing to provide an avenue for safety when officers are bona fidely threatened. Madam Chair, I have one witness, Randy Perry from Borac.
Thank you.
Madam Chair, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC, sponsors of the bill. This bill does not give a peace officer any more authority than they have now. They can already go to court and try to enjoin a video if they can prove that it is a danger to themselves or their families. It's a very high bar. The last 2 more high-profile cases, Long Beach and Bart, both the peace officers both lost. When the judge is looking at this bar, they're looking at the constitutional right of the public to know what's going on, and so it's a very difficult bar to get over. They have to literally show something that is endangering them or their family. They have to show videos, graffiti, actual threats to them by emails or other social media in order for them to win this. These rarely go to court. We're simply trying to say that during that 10-day period, if there's a CPRA request, generally the department has 10 days in which to respond. During that 10 days, we want the department to notify the officer that the request has come in. So that if the officer feels there's a danger and they can prove it, they can go to court. Other than that, it does not extend, and it's not our intent if it does. It does not extend the 10-day period. It does not work to hold the release of the video in any way. It simply allows them to get ahead of the upload so that they're not just going to court to try and get it back down after the damage has been done. So that's all we're asking in this bill. Thank you.
Thank you. Others in support of the bill?
Madam Chair and members, Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, and the Riverside Sheriffs Association, all in support. Thank you.
Others in support? Seeing and hearing none, are there speakers in opposition to the bill? Please come forward.
Madam Chair, members, Jim Ewert for the California Newspaper Publishers Association. This bill really is a threat to the safety of a community. By requiring 3 days' notice prior to any disclosure of these videos, it takes away the discretion of the management of the cities and counties to use the video to calm any potential harm that could result from rioting or any other activity that can cause risks to the community safety during a very emotional event. Excuse me. Moreover, it really threatens the Public Records Act, and a very hallmark of the Public Records Act is to provide access to information in a timely manner, and by allowing or encouraging, I should say, law enforcement officers to run to court to seek an injunction to prevent the disclosure of information, it creates delays that can take months, if not years, until all of the hearings and appeals take place. And in the cases where Mr. Perry referenced, both in Long Beach and in Pasadena, that's exactly how long it took. So that information that was sought.
Excuse me, how long?
Months or years. In the case of the Long Beach situation, it was at least a 2.5-year period until the Supreme Court ruled. And so that information was not disclosed for a very lengthy period of time, and that is precisely why we are urging a no vote on this today. Thank you very much.
Good morning, Madam Chair and members. Kevin Kevin Baker for the American Civil Liberties Union, also joining in opposition. We see the bill as a real threat to transparency and accountability. We don't know of any other correlative right where officers or anybody else has the right to prevent release of information in advance. This is a prior restraint, and we're opposed for the reasons stated in opposition by other organizations. Thank you.
Madam Chair, members, Corey Salzillo on behalf of the California State Sheriff's Association in opposition.
Mr. Salzado, could you actually explain why? This looks to me like law enforcement, labor versus management, and I'd like to hear from.
I think that's how the support and opposition breaks down. I don't know if I characterize it as management versus labor, but sure. No, management certainly understands the concerns of labor in not wanting to have something that's potentially dangerous being released. But the bill just sort of sets a bright line and says that a video, that you must give 3 business days notice to the officer before releasing the video. And there could be circumstances, although I suspect it would be rare, but there could be circumstances where a law enforcement agency makes a decision that they need to release some sort of footage, and then the officer individually may disagree with that decision. And in this case, there's really no waiver or wiggle room for the officer to say, yes, okay, I'm okay with that. It just sort of says you have to give that 3 days wait. And so that's our concern, is the lack of flexibility in determining. I mean, agencies are going to be very thoughtful about how they release and when they release, and they're going to take into account any number of circumstances, the community, what they believe is important, whether it's evidence, whether or not it could endanger the officer. They're going to look at all of those things, but this just sort of creates an inflexible directive that you have to wait 3 days.
Okay, and this is essentially about footage from body cameras, right?
It's not limited to that, but I suspect that would be the majority of the practical implications.
Let me ask the author that.
We're only limiting it to video cameras as the bill is written.
So video cameras could be media, could be
Only those that are
passerby.
only those that are body cameras.
Okay, so those are, okay. Thank you. Others in opposition?
Khalif Osagai, California Public Defenders Association. I'm in opposition to 2533 as well as 1276, which was heard earlier. Thank you.
Okay, thank you. Yes, Senator Glazer.
I had a question to Mr. Salzillo and also to Mr. Eward, if you could come back up. Mr. Salzillo, I'm struggling with this because you've argued that it's a burden, right, to have this requirement. Isn't it possible that you could have just as a submittal on any kind of police report that involves video, an acknowledgement that this may be released by the department and therefore 3 days notice is hereby given that that's a possibility? Right from the beginning, just from the submittal of a police report that includes video. Isn't that something that procedurally could be done?
I suspect procedurally that could be accomplished in the manner in which you described, but I don't think that addresses the concern that we have, which is even if we had given that notice, this bill doesn't allow us to release the footage without the 3-day wait. And that's the concern we've raised.
But the 3-day wait could occur in the midst of a PRA, right? I mean, it could happen during that 10-day period, but what I'm saying is, why couldn't it just be as a regular course of business? That if you are submitting a report that includes any kind of video, which I assume would be a common occurrence, that it would be part of the disclaimer, the waiver in some ways, that they've received the notice that 3 days starting now would run, and doesn't mean that anything's going to be released, but at least you've given the notice as required by this bill.
That would still preclude management from making a decision to release the video.
It would. Why would it preclude management? You can decide not to release. Maybe no request has ever been submitted for 99.9% of video that's taken. No request ever comes in, but at least you'd have the sign off from the officer that notice has been given and that the 3-day clock begins when the report's been submitted.
But, and not through the chair, not to create a colloquy, but the issue at bar here is whether or not management can release the video at a certain time. It's not so much the notice. I mean, the bill says you have to give the notice, which this bill would require, but we would not. But even if we gave the notice in the manner in which you described, we would still have to wait the 3 days.
Yes, sir.
That's our objection.
Got it. Okay. And then to Mr. Eward, if I may, Madam Chair,
Yeah.
You've said some things that are pretty strong here this morning. You said that it's a threat to the safety of a community, and we're talking about this 3-day notice issue, that it threatens the Public Disclosure Act. It's going to take months and years of delay. This bill, how would this bill have affected the months and years of delay? Because they could, whether 3 days notice is given or not, the officers in those cases could have, and in fact they did. They didn't get 3 days notice. They took whatever action under existing law to challenge the release, and that procedure took months and years. But how would this bill affect those examples in any way?
It's our determination that now with notice going out, every time a request is made for information that includes body cam footage, and oftentimes it can be as simple as we just want all the records associated with the beating of citizen A.
I know, but I'm dealing with the issue of, you
No,
said
wait a
months and
minute.
years
We're
of
having
delay.
a colloquy, and we're not going to do that. We have 36 bills up. Okay, would you finish? And then if there's another question, Senator Glazer will ask it.
And by encouraging these officers to do this, we fear that in each and every instance, every time a request is made that involves an officer, that they're going to run down and they're going to file for an injunction. And in that process, the judge is not required to use the Public Records Act in making a determination whether that injunction should be issued, nor is there a requirement that the requester be notified so that he or she can go down to that hearing and intervene in that hearing to assert the public's interest in that situation. And we think that that is just wrong.
Madam Chair, may I have a follow-up question?
Yes.
I'm not sure that I heard a direct answer to how this legislation would affect that, except that it is a new practice. You know, the body cameras are new. This video accessibility is a newer issue, and I'm not sure I heard clearly that this is somehow going to create this enormous proliferation of officers going to court to prevent it. But the other issue that you raised is that, and you say this is going to be a stranglehold over information, stranglehold, and I'm again struggling to see how 3 days of potential delay, and I think that if the police agencies actually incorporated the fact that there may be video release right from the beginning, that there really would be no delay, that somehow that's going to create a stranglehold over information. So struggling to see, I'm sympathetic to disclosure, don't get me wrong, but I'm struggling to see how the world is going to crash because this bill would be put into effect.
I can respond
If you want.
Just that it goes beyond just the 3-day period. It's the delay that is caused by the parallel proceeding, which we're calling a Public Records Act slap lawsuit. In addition to that, it takes away the discretion of the agency to respond immediately. The requirement in the Public Records Act now is to respond to a request promptly. And a determination on the discretion of the agency to disclose the record can take place within maybe hours if it is so vital to get to the public. This delays that for up to 3 days. And with respect to your proposal to Mr. Salzillo, oftentimes a request will come in for the information before a report is even prepared. And so it would still constitute a delay in that manner as well.
Okay, thank you.
Thank you. I'm going to establish a quorum while we have 6 people here. Please read the roll.
Hancock.
Here.
Anderson.
Here.
Anderson here. Glazer.
Here.
Glazer here. Leno. Lou. Lou here. Monning.
Here.
Monning here. Stone.
Here.
Stone here.
Okay, thank you all. Yeah, Senator Monning.
Thank you, Madam Chair. So I just wanted to clarify, I think it was Mr. Perry who indicated existing law allows an officer to seek a restraining order not to release this footage if that officer, if he or she thinks they may be at risk by the release of that. Is that correct?
Correct.
What is the current law with respect to dash cams in vehicles?
It's exactly the same thing. Right now, the video on dash cams, CCTV, any other type of video, they generally can preview it before they make their reports, and they can see if there's something in there potentially dangerous. At that point, they try and work with management to see if they can do something about it. But
So
under
there is a-
body cams, it is not covered yet, because it's new.
With the dash cam, there's not a 3-day hold on dash cam.
There is not. So what has been occurring is they're going to court to try and get it. If it's released, they're without notice, they're trying to go and get it pulled back down, but a lot of times it's too late.
And just for clarity so that we're clear on it, when we took a look at this early on, the provisions that we're really looking at was originally if it's a identification and or picture of a police officer that is released, and then you can go into the said process. So there really isn't an opportunity to prevent this from getting out should there be bona fide danger to a police officer or their family, because the information is released and then you're allowed to go through the process. So in some ways, you're notifying the police officer via them getting to know that the information is not released. So what we've been saying is, look, there are situations where a police officer's family and or a police officer is in danger. Now, look, I've sat with the opposition now 3 times and asked for clarifying language that would help us to get over that hurdle. In no way do we want to prevent the Public Records Request Act from being fulfilled. And in fact, we started off this conversation with a 5-day period. We began to realize that that only gives 5 more days to complete the public records request, so we narrowed it down to 3 days. You know, and I've even asked the question, and I'm glad that the opposition has sat with us a number of times now to take a look at this. Would 24 hours work? Would 2 hours work? And really, the challenge here is identifying the right balance between when there is danger to an officer and the immediate release. And there's a lot of assumptions here too. The assumption is that every time a police officer is notified, they're going to run and create an injunction. That's just not going to happen. I mean, it's costly to the police officer. If the union were to pick it up, it's going to be costly to the union. There's going to have to be safeguards in place. And look, I'm willing to, and I've said this from the very beginning, put in there language that allows to figure out what is bona fide danger, what is not bona fide danger. But there's got to be a striking balance. When I took a look at this issue last year, and mind you, I supported all the bills that were aimed at disclosure. I continued to support them this year, and I would call myself someone who believes strongly in the Public Records Request Act. You know, even if you were to take this and say we're limited for 3 days, you still have 7 days to fulfill the Public Records Request Act. Now, this isn't going to. Police officers are not going to jump every single minute. But what if there is an opportunity when there is threat to a police officer to prevent that one particular video from getting out? And that might be worth it. Okay, and I'll ask the question again. You know, could you help me with clarifying language or some safeguards in place when there is danger to a police officer? Because there's got to be a balance.
Just to my question, if I might, is there anything that prevents an officer today who fears that information in a video could be dangerous from alerting management to that and seeking protection from day one after the incident?
No, there's nothing that prevents that other than them having knowledge that they're going to
And is there
release it.
anything in current law that would prevent management from reaffirming with members or unions telling their members, remember, if you're involved in an incident where you think disclosure may compromise your safety, please alert us so that we might take action to protect.
There's nothing preventing management from notifying on their own.
Thank you.
Okay, thank you. Are there other questions or comments? I don't know if there is a motion on the bill. Would you like to close?
Yes, Madam Chair. I didn't address the management portion. Actually, I would love to continue to work with you on this because I think that's a space that maybe I didn't pay enough attention to, and I have to admit to the committee staff, and would love to continue to work with you and the opposition on the newspaper side. Look, I just want language that will address the core of what we're getting to if there is bona fide danger. And I will include it in there, and I will write it in there to continue this conversation forward. Madam Chair, thank you for allowing us the opportunity to discuss this here today, and I'll respectfully ask you for an aye vote.
Okay, thank you. This is one of the bills I was referring to that I think deal with basic constitutional issues and also on the very tough topic of police community trust and partnership. And I really thank the author for bringing the bill and for the thoughtful testimony on all sides of the issue. For me right now, body cameras are a relatively new practice. I'm ready to leave it to local jurisdictions as they adopt policies. We have legislation requiring policies. And see what devolves. But I think the question isn't would the world crash if this was adopted, but would the world be a better place if this was adopted? And that's something that right now, given police community relationships in my area, I don't think the world would be made better. I would really encourage PORAC and the associations to work together, but most importantly, as each individual jurisdiction creates its own policies now for body cameras, to look at these situations, and that if you can come up with a bill next year, that would be great. If not, let things settle. Let's see what works. Let's see where there are problems. I am concerned about the long delays in the judicial process. Should we have a rush of seeking injunctions? So I will not be able to support the bill today. I don't know if there is a motion on the bill. I haven't heard one.
Madam Chair, if the author wouldn't mind coming back up for just a second, would you like a motion on the bill today?
I absolutely would love a motion on that.
I'll move it.
Thank you, Senator Anderson. Please read the roll.
I'd even love a vote a lot more.
Don't get pushy.
Right. Hancock?
No.
Hancock, no. Anderson?
Aye.
Anderson, aye. Glazer? Aye. Glazer, aye. Leno? Lou? No. Lou, no. Monning?
No.
Monning, no. Stone?
Aye.
Stone, aye.
Okay, that bill has 3 votes. I'll leave the roll open for the absent members.
Madam Chair, I'll move the consent calendar.
Thank you. The consent calendar has been moved. I read the consent calendar originally. We added one item by Assemblywoman Olson. I believe it's item 37 to the consent calendar.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Glazer?
Aye.
Glazer, aye. Leno? Lou? Lou, aye. Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.